55. Entel. Ham RL Joni HTBRARG. JLAT 0 LJA Scott Eoltitot. SIFT of IE 31. MSITB U. 5 LFFI. 1. 1B94. Cornell University Library. The original of this book is in the Cornell University Library. There are no known copyright restrictions in the United States on the use of the text. http://www.archive.org/details/Q319240842598872. A Treatise. On Suits in Chancery. Setting forth the principles, pleadings, practice, proofs and processes of the jurisprudence of equity, and giving numerous illustrative forms of pleadings, writs, orders, reports, decrees and other proceedings in suits in Chancery, from their beginning to their ending, besides many practical suggestions. 4. Solicitors and Masters. Cursus Curis est Lex Curia. Henry R. Gibson, A.M., LL.D., Chancellor of the 2nd Chancery Division of Tennessee, 2nd edition, revised and enlarged. By the author. Knoxville, 10. Gout Ogden, Colorado, Printers and Binders. 1907. Entered, according to Act of Congress, in the year 1907, by Henry R. Gibson. In the office of the Librarian of Congress, at Washington. To greater than my wife, Frances Reed Gibson, this book is dedicated, as a to ken of my appreciation of her sympathy and assistance during its preparation. Preface to the first edition. While there is a general family resemblance between the systems of jurisprudence prevalent in the various states of the Union, the differences and peculiarities in their systems of pleading and practice are, nevertheless, so great that no work, dealing with the procedure in courts, is of much practical value to the practitioner, unless it is adapted to the jurisprudence and practice of the particular state in which he lives. Books of general practice, with footnotes of the diverse rulings in various states, are often more confusing than enlightening. What the practitioner needs is a book on court procedure that omits everything that is not the law in his own state, and contains everything that he is likely to need in the progress of a suit. Such a book I have endeavored to make this, so far as the Chancery practice is concerned. What ordinarily happens in a litigation can well be compressed into one volume. But what very seldom happens, the unusual and the possible, would fill several volumes. What happens in matters of pleading and practice in 99 out of every 100 suits, I have labored to give. What may happen in the 100th suit, I have not striven to forecast. The ordinary law is comparatively small in compass. It is the exceptional and the uncommon that necessitate a multiplicity of books, and fill libraries. And while I have not attempted to give what is exceptional and uncommon, my purpose has been to give everything likely to prove of value, to be found in our statutes, decisions, and rules of practice, and in standard authorities on the subject. 1. In matters of equity jurisprudence, this work is based mainly on Pomeroy, Story, and the statutes and judicial decisions of our own state. 2. In matters of Chancery pleading, I have followed Story, insofar as consistent with our statutes. Daniel and Barber have, also, been drawn on, quite largely. The many differences, between our system of pleading and that of the English Court of Chancery, are clearly pointed out, where necessary to prevent confusion. 3. In matters of Chancery practice, the works of Daniel and Barber have been relied on when consistent with our statutes, decisions, rules of practice, and system of jurisprudence. V. Preface. 4. In drawing the forms, pleadings, orders, and decrees, brevity, simplicity, perspicuity and precision have been constantly kept in view, and surplusage and prolixity have been avoided and reprehended. 5. In the arrangement cf. the contents of the book, everything has been given in the order of time in which it usually takes place in the progress of a suit, when possible so to do. 6. In providing means for finding any particular matter in the book, a full index has been given in the back part of the book, and a complete table of contents in the front part of the book, and the titles of the chapters and articles have been given in the top margins of the book, and many cross-references will be found in the footnotes. Each section begins with a statement of its subject, in bold-face type. The object of this work is to aid those who minister in the Chancery courts, and to contribute somewhat to the improvement of the pleadings and practice in those courts. Henry R. Gibson. Preface to the second edition. Whatever a man does he flatters himself he can improve on, and so the author of the first edition of this work, better aware of its deficiencies than anyone else, began the preparation of what he hoped would be an improved edition before the first had been fully printed. The main object of the original edition was expressed in its title and preface, but it left many suits in Chancery unconsidered, and left others very imperfectly considered. To supply these deficiencies is the main object of the present edition. The deficiencies in the first edition were caused, first, by an apprehension that the necessary additional matter would make too unwieldy a volume, and second, by the author's duties as Chancellor engrossing too much of his time. In preparing this edition, the author has had adequate time, and the suggestions of a considerable proportion of the lawyers of the state, besides the use of the Law Library of Congress for over 10 years, so he hopes the deficiencies have been reduced to the minimum consistent with one volume. The present edition, which contains 20% more matter than the original, treats of every kind of suit in Chancery the average lawyer will be called on to bring, or defend, in an average lifetime, to the suits oftenest brought being most fully considered. The author cannot forbear expressing his gratitude to the judges and chancellors of the state, and to the members of the bar, for their kind reception of the first edition. It largely compensated him for the drudgery devoted to its compilation and publication. In this connection it may not be out of place to say, that none of the references to reports and textbooks in either edition are second-hand, but are the results of original investigation, and can be implicitly relied on. The code references are, unless otherwise noted, to the Code of 1858. The reasons for this are, first, it is the only statutory code of the state. 2d. All subsequent codes contain it, so far as extant. And third, this work may outlive the temporary codes of individuals, of which there have already been 4, but cannot hope to outlive the code of the state. Statutes passed since the Code of 1858 are usually referred to by the date and chapter of the Act. The quotations of maxims to illustrate the text will, it is believed, prove helpful. No book that treats of equity is complete without them. They are not the mere gewgaws of pedantic lore, but the crystallized wisdom of the law, polished and preserved by the masters of jurisprudence. Henry R. Gibson, Knoxville, Tennessee, March 4, 1907. 161 old sections have been omitted or consolidated, I to ad a accus frequentius accident jura adaptantur. And 244 new sections added. Over 1,000 of the old sections have been rewritten, or revised. I. Contents. Part 1. The Chancery Court. Its history, jurisdiction, and principles. Chapter I. The history of the Chancery Court. Sections. Article 1. The origin and evolution of equity jurisprudence 1-9. 2. The history of the Chancery Courts of Tennessee 10-15. Chapter 2. Jurisdiction of the Chancery Court. Article 1. Jurisdiction of the Chancery Courts generally considered 16-22. 2. Equitable, or inherent, jurisdiction of the Chancery Court 23-25. 3. Statutory jurisdiction of the Chancery Court 26-30. Chapter 3. Maxims and principles of equity. Article 1. Maxims and principles of jurisdiction 31-40. 2. Maxims and principles of adjudication 41-63. Maxims applicable to the court, and to its practice and pleadings 61-64. Chapter IV. Notice, lee pendens, estoppel, acquiescence, negligence, laches. Waiver and consent. Article 1. Notice, lee pendens, estoppel, acquiescence, negligence, and laches 65-70. 2. Waiver and consent 71-72. Chapter V. Priorities, and bona fide purchasers. 73-76. X. Contents. Part 2 Proceedings in a suit in Chancery, from its prelimina. Rise to the appearance of the defendant. Chapter V Proceedings preliminary to a suit. Sections 77 to 79. Chapter 7. Parties to suits in Chancery. Article 1 Who may sue in Chancery. 2. Who may be sued in Chancery. HI General rules as to parties IV. Who should be complainants. V. Who should be defendants. V. Next friends and guardians ad litem 7. Ms. Joinder and non-joinder of parties 8. Effect of death or marriage of parties, or assignment of their interests. X parties in particular suits X. Parties in suits by and against the state, counties, cities, and corporations. Chapter 8. Original bills in Chancery. Article 1. Original bills generally considered. 2. Frame of an original bill. 3. Form of an original bill. IV Practical suggestions as to the drawing of bills. Chapter X Proceedings preliminary to process. Article 1. Proceedings preliminary to extraordinary process. 2. Filing of the bill. 3. Proceedings in reference to costs. Chapter X. Original process in Chancery. Article 1. Original process generally considered. 2. Subpoena to answer. 3. Process by publication. IV attachment to compel an answer. Chapter 11 Proceedings between process and appearance. Article 1. Pro confessos, and proceedings thereon. 2. Motions by the complainant. 80, 85, 86, 89, 90, 95, 96, 99, 100, 102, 103, 108, 109, 112. 113, 116, 117 to 127. 128 to 131. 132 to 138, 139, 152,153, 164, 165 to 173. 174, 176,177, 179, 180 to 183. 184, 186,187, 195,196, 200, 201 to 204. 205 to 213, 214 to 221. Contents. XT Part 3. Proceedings in a suit in Chancery, from the appearance of the defendant to the close of the pleadings. Article 1, 2, 3. Chapter 12. Appearance and defense. Appearance by the defendant. Defenses generally considered preliminary motions by the defendant. Sections 222, 228,229, 232, 233 to 239. Chapter 13. Pleas in abatement. Article 1. Pleas in abatement generally considered 240 to 243. 2. Pleas in abatement to the process 244 to 246. 3. Pleas in abatement to the bill 247 to 252. IV frame and form of pleas in abatement 253 to 254. V. Pleas in abatement in attachment suits 255 to 259. V. Proceedings upon a plea in abatement 260 to 265. Chapter 14. Motions to dismiss bills 266 to 274. Chapter 15 Demurrers. Article 1. Demurrers generally considered 275 to 280. 2. Demurrers by allowance 281 to 288. 3. Demurrers of right 289 to 300. IV rules governing demurrers 301 to 308. V. Frame and form of demurrers 309 to 312. V. Action of the court on demurrers 313 to 316. 7. Practical suggestions concerning demurrers 317 to 319. Article 1, 2, 3. IVV. Chapter 16. Pleas in bar. Pleas in bar generally considered 320 to 324. Kinds of pleas in bar 325 to 334. Frame and form of pleas in bar 335 to 340. Pleas supported by an answer 341 to 349. Proceedings upon a plea in bar 350 to 354. XLL. Article 1, 2, 3, IVV, V. Contents. Chapter 17, Answers and Disclaimers to Bills. Sections. The answer is a pleading. 355 to 360. The answer is a deposition. 361,367 matters common to all answers. 368 to 376. The frame and form of an answer. 377 to 386. Practical suggestions as to answers. 387 to 392. Disclaimers to bills. 393 to 398. Chapter 18, Cross Bills. 399 to 401. Chapter 19, The Joinder of Different Defenses to A Bill 402 to 405. Chapter XX, Analysis and Comparison of Pleadings. Article 1, Rationale of Pleadings. Two different defenses distinguished. Chapter 21, How Pleadings are Tested. Article 1, Testing the Sufficiency of Pleadings. Two exceptions to answers. 3. Suggestions as to testing pleadings. Chapter 22, Amended and Supplemental Pleadings. Article 1, Amendments to Pleadings Generally Considered. 2. Amended and Supplemental Bills. 3. Amended Demurrers and Pleas. IV. Amended and Supplemental Answers. 406 to 410. 411 to 415. 416 419,424 24 425 to 426. 427 429,430 431,432 433 434 to 437. Part 4, Proceedings in a Suit in Chancery, Aram the Close of. The Pleadings to the Conclusion of the Hearing. Chapter 23, Hearing a Cause on Bill and Answer. 438 to 440. Article 1, 2, 3, IVV. Article 1, 2, 3, IVV, v. 7, 8. Contents. Chapter 24, Evidence in Chancery. Evidence generally considered when proof is, and is not, necessary. Pleadings when evidence. When proof must be filed. Practical suggestions concerning proof. Chapter 25, Depositions in Chancery. Depositions generally considered. Notice to take depositions. Depositions taken on interrogatories. Formalities of a deposition. Powers and duties of commissioners, and rights and duties of witnesses. Exceptions to depositions. Amendment of depositions. Practical suggestions about depositions. XLLL. Sections 441 451,452 457,458 462,463 468 469 to 473. 474 479,480 482,483 485 486 to 491. 492 496,497 501,502 504 505 to 513. Chapter 26, Motions previous to the hearing. Article 1, Motions before the case is called. 2. Motion for a continuance. 3. Motions to dismiss the bill. IV. Suggestions how to prevent delays arising from amendments and continuances. Chapter 27. The hearing, or trial of the cause. Article 1. The hearing, by the Chancellor. 2. Incidents of the hearing. 3. Trial by jury. 514 518,519 522 523 to 525. 526 to 529. 530 538,539 546 547 to 554. Part 5. Proceedings in a Suit in Chancery, from the conclusion of the hearing to the enforcement of the decree. Chapter 28. Decrees on the merits. Article 1. Nature and extent of the relief granted. 555 to 563. 2. Decrees generally considered. 564 to 574. 3. Kinds of decrees. 575 to 579. IV. Practical suggestions as to decrees. 580 to 581. 14. Article. Contents. Chapter 29. Decrees as to costs. I. Costs generally considered to the adjudication of costs. Sections 582s8s 586 to 593. Chapter XXX. References to the master and proceedings thereon. Article 1. When references are necessary, or proper. 2. Proceedings upon a reference. 3. The master's report. IV. Proceedings upon a master's report. Chapter 31. Decrees of sale and proceedings thereon. Sales generally considered report of sales, and proceedings thereon opening of biddings purchasers' duties, rights and liabilities payment of money under a decree to parties entitled. Article 1, 2, 3, IVV. Article 1, 2, 3, IVV. V. Chapter 32. How decrees are enforced. Final process generally considered transfer of title by decree, or deed. Final process against the person. Final process against property. Sequestrations to enforce decrees. Proceedings in enforcement of decrees on remandment. 594 600 2603 610 611 614 615 to 620. 621 627 628 633 634 639 646 43 644 to 645. 646 648 649 650 651 652 billion 653 million 657 658 661 662 to 665. Part 6. Bills in Chancery relating to original bills. Chapter 33. Amended and Supplemental Bills. Article 1. Amended Bills. 2. Supplemental Bills. 3. Defenses to amended and supplemental bills. Chapter 34. Abatement and Revivor. Article 1. Bills of Reviver. 2. Statutory methods of Reviver. 3. Bills akin to bills of Reviver. IV. Defenses to proceedings to revive. 666 679 686 92 693 to 697. 698 709 710 716 717 719 720 to 722. Contents. 15. Chapter 35. Sections. Bills to carry decrees into execution. 723 to 724. Chapter 36. Cross Bills. 725 to 738. Part 7. Interlocutory applications in suits in Chancery, and proceedings thereon. Chapter 37. Motions in court, and proceedings thereon. Article 1. Motions generally considered 739 to 743. 2. Motions by the complainant 744 to 749. 3. Motions by the defendant 7S07S2 IV. Motions common to both parties 753 to 762 v. Motions by strangers and quasi-parties 763 to 764 v. Motions about paying money into, or out of, court 765 to 769. Chapter 38. Motions at chambers, and proceedings thereon. Article 1. Jurisdiction of the Chancellor at Chambers, 770 to 775. 2. Proceedings before the Chancellor at Chambers 776 to 783. Chapter 39. Affidavits. 784, 790. Chapter XL. Petitions. 791, 799. Chapter XLI. Suits for injunctions, and proceedings therein. Article 1. Injunctions generally considered 8C0 to 803. 2. In what cases injunctions will be granted 804 to 826. 3. How injunctions are obtained, issued, and served 827 to 837 IV. Pleadings in injunction suits, and reliefs granted 838 to 844 v. Violations of injunctions, and remedies therefore 845 to 848 v. The dissolution of injunctions 849 to 858 7. Injunction and refunding bonds, and their breach 859 to 863. Chapter XLI.